Well, welcome to the 2023 Watershed Congress. My name is Autumn, and I am Development and Member Programs with the Delaware Riverkeeper Network. I'm also your moderator for this session, the Clean Water Act at 50, and I am pleased to present our speaker for this session, Kacy Manahan. Kacy is a senior attorney with the Delaware Riverkeeper Network. Her work focuses on the challenges to natural gas infrastructure, federal permitting challenges, and both federal and state environmental law. Without further ado, I'm going to go ahead and turn it over to Kacy.
Thank you, Autumn. Let me get my slideshow set up here. Okay, so this presentation is generally the basics of the Clean Water Act. This is in honor of the Clean Water Act's 50th anniversary, which was technically last year. But just like the ongoing effort of cleaning up our nation's waterways, I think that we can have a little bit of an ongoing celebration of the Act's anniversary. So the history of today's Clean Water Act is very long and very detailed, but the basic outline is that prior to its enactment, pollution was generally seen as an issue for states to address through state law. The first successful federal act that addressed water pollution was the Federal Water Pollution Control Act of 1948. And what that law did was it kind of supported states in the setting of water quality standards and things like that, but didn't really include a strong enforcement mechanism, and thus it was largely unsuccessful in reducing pollution across the country. In 1970, some of you may be aware of the history of the environmental movement in the United States in the 20th century. And, the 1960s were a big time for environmental concerns to be aired, and very many demonstrations and organizations were created to help advance environmental concerns. On the left here, you can see a photo of Senator Edmund Muskie, who was in Congress at the time in the 1970s, and was very instrumental in getting a lot of these large federal environmental laws passed, like the Clean Air Act, the Clean Water Act, RCRA, Endangered Species Act, things like that. And the podium that he's standing at, it's hard to see, but it says Earth Week, April 22nd. So, that's the date that we celebrate Earth Day now, but that's, it was the very early stages of those types of celebrations in the 1970s. So in 1970, the United States Environmental Protection Agency was created. That was also the same year that the Clean Air Act was enacted. And then in 1972, the Clean Water Act was enacted as an amendment to the 1948 Federal Water Pollution Control Act. And there was additional amendments in 1977 that focused specifically on toxic pollutants and wetlands. So the really outstanding thing about the Clean Water Act were its goals, as well as, the main provision, Section 301, which we'll discuss a little bit later. But the goals of the Clean Water Act were to restore and maintain the chemical, physical, and biological integrity of the nation's waters, to eliminate the discharge of pollutants by 1985, and to achieve the goal of, where attainable, water quality, which provides for the protection and propagation of fish, shellfish, and wildlife, and provides for recreation in and on the water by 1983. And those were that was known as the fishable, swimmable goal. And those uses listed there are often referred to as the Section 101A uses. The way that the law works is through cooperative federalism, which means that the federal government, states, and certain Native American tribes, where applicable, share authority in implementing the Clean Water Act and working towards its goals. So some examples of the divided responsibility here are that states and tribes can set water quality standards for the waters within their borders. They can issue permits if they're authorized by EPA to do so. They can enact laws and regulations that control non-point sources of pollution, which is what would be commonly referred to as runoff, such as from parking lots and other types of land use. The federal government, on the other hand, sets effluent guidelines for industrial categories based on the performance of treatment and control technologies. So For example, cement plants, they'll identify a category such as cement plants and say, this is the best technology that can be used to limit the amount of contaminants in their effluent that they discharge into streams and waters. They also review the state and tribal water quality standards to ensure that they meet the objectives of the Clean Water Act. And they can also review and authorize applications from states and tribes to implement Clean Water Act permitting programs, such as Section 402 permits or Section 404 permits, which we'll learn about a little bit later. Another unique aspect of the Clean Water Act, maybe not so unique to environmental laws, but unique to laws in general, is the inclusion of citizen suits, which means that citizens also have a role in the enforcement of the Clean Water Act. Section 505 of the Clean Water Act allows a citizen to file suit in federal district court to enforce the Clean Water Act against either a private actor, like a company that is discharging, or someone who is illegally discharging into the streams or fills in a wetland with dirt or gravel, or the citizen suit can be brought against the government if the government does those same actions. They can also be used against the EPA to force EPA to take actions that are required by the Clean Water Act. So those are non-discretionary actions under the statute. If the statute speaks very clearly and says, EPA, you must do this, and then EPA fails to do it, you can bring a citizen suit to try and force them to do it. One of the main issues in citizen suits is that a citizen has to have standing to sue. And you may have heard this term before. It ends up in a lot of legal news, for very high profile Supreme Court cases. So it means that a plaintiff who brings a case has to have a concrete and particularized actual or imminent injury. And that injury has to be fairly traceable to the defendant's challenged conduct. And the injury has to be likely to be redressed by a favorable decision by the court. So a classic example would be, I live next to the stream. My neighbor has been discharging their disgusting chlorinated pool water into the stream, and it flows down my property. It stinks. It's been killing the fish and the bugs and things like that. I'm bringing this neighbor to court, and I'm going to get them to stop under the Clean Water Act. I'm going to enjoin them from discharging any further. And so that's a clear example, because that stream is near their home. They would typically enjoy it if it wasn't polluted. And if they go to court and get an injunction, then that will prevent that pollution. So Section 301, which is the keystone provision of the Clean Water Act, prohibits the discharge of any pollutant by any person. And that seems to be very vague, but these words have really specific regulatory and statutory meanings. The discharge means any addition of any pollutant to navigable waters from any point source. And so pollutant, that's a very easy one, because it could be pretty much anything other than the water itself. It could be water from a different body of water. It doesn't have to be toxic, or it doesn't have to be harmful. It just has to be something that changes the makeup of the water that is being polluted. Navigable waters, on the other hand, are known as waters of the United States. And that term is defined by regulation, and the Environmental Protection Agency and the U.S. Army Corps of Engineers, they both work on that regulatory definition and revise it. They've been revising it every few years these days because it's very controversial. But they both work on it jointly because, as you'll see, the Army Corps of Engineers has an important role in the Clean Water Act along with the EPA. And a point source, there's a photo here on the right. This is like a classic point source. It's any discernible, confined, and discrete conveyance, like a pipe going into a stream. It could also be it could be a truck dumping something into a stream. It could be anything that helps facilitate the discharge of a pollutant into the water of the United States. And those aspects there, discernible, confined, and discrete, are what really identify what a point source is. recent case in the Supreme Court in 2020 called County of Maui versus Hawaii Wildlife Fund was very interesting and groundbreaking because groundwater, which is, the water that is not visible, it's the opposite of surface water, and it travels through soils and rocks beneath the ground, is typically not considered, well, it's almost never considered a water of the United States. So pollution of groundwater is not something that is of concern to the Clean Water Act. But in County of Maui, the court held that if someone discharges from a point source and that pollution from that point source goes through groundwater and essentially is so discernible, confined, and discrete in its discharge through the groundwater to a surface water, then it may end up being the functional equivalent of a direct discharge. So there is now a role for groundwater in the Clean Water Act, but this is going to likely be a very fact-intensive inquiry as to whether it's the functional equivalent of a direct discharge. So I have a few slides on waters of the United States. You can really get bogged down on this issue, but it is one of the main controversies in the Clean Water Act, and you'll probably see it in the news when you look up, environmental law, Clean Water Act, Supreme Court cases. It has gone up to the Supreme Court at least 4 times now. And so the current regulatory definition is very recent. It was published in January, and it just took effect last week, last Monday. And lawsuits have already been filed by states and by other interested parties. And this new regulatory definition is currently stayed, which means the court issued an order saying it's not law in Texas or Idaho. So the current regulation says that the federal government has jurisdiction over traditional navigable waters, the territorial seas, and interstate waters. And these are the really non-controversial waters. They're clearly within the federal jurisdiction, the Commerce Clause. And these are known as paragraph A1 waters. The second category is impoundments of these waters, known as paragraph A2 waters, or paragraph A2 impoundments. And then there are tributaries to either A1 or A2 waters when the tributaries meet either a relatively permanent standard or the significant nexus standard. Those are 2 standards that were created by a 2006 Supreme Court case called Rapanos. And that case was a plurality where which means that the Supreme Court justices were split and there was no majority opinion. And so the 2 opinions that got the most votes were Justice Kennedy's opinion, which established the significant nexus standard, and Justice Scalia's opinion, which established the relatively permanent standard. So the regulation now is using both standards in different ways. The jurisdiction over wetlands, which is, kind of a different kind of water than tributaries and streams and seas and things like that, include wetlands that are adjacent to A1 waters, adjacent to and with a continuous surface connection to relatively permanent A2 impoundments, adjacent to tributaries that meet the relatively permanent standard, and adjacent to A2 impoundments or jurisdictional tributaries when the wetlands meet the significant nexus standard. And then also intrastate lakes, ponds, streams, or wetlands not identified elsewhere that meet either the relatively permanent or the significant nexus standard. So those 2 standards here briefly, relatively permanent means relatively permanent standing or continuously flowing waters connected to A1 waters and waters with a continuous surface connection to such relatively permanent waters or to A1 waters. And I think the reasoning behind this test is that it should be easy to visually tell if this water is jurisdictional. This is an issue that was recently discussed in the Sackets case in the Supreme Court, which we'll talk about a little bit on the next slide. And the justices, this was argued last October. It was the first argument of the term, the Supreme Court term. And the justices were really struggling with the concept of kind of this tension between the significant nexus standard, which really focuses on scientific connection between these waters, and the relatively permanent standard, because one argument is that it should be easy for the average person to look at a water and say, oh, this looks like it's going to be jurisdictional under the Clean Water Act. Or if you're going to achieve the goals of the Clean Water Act, you need to have a scientific basis for asserting jurisdiction over these waters and protecting them from pollution. So, the significant nexus test, which quotes some of that language from section 101 that we discussed earlier, says there's a significant nexus if the waters, either alone or in combination with similarly situated waters in the region, significantly affect the chemical, physical, or biological integrity of the A1, those traditional navigable waters. So the new regulation lists several functions that the typically the Army Corps will look at in determining if there's jurisdiction over the water, and other factors to be assessed in making that determination. And also the term adjacent, that was another issue in the Sackets case, which means bordering, contiguous, or neighboring to another jurisdictional water. So here's a little bit about the Sackets case. I don't know how well you can see this, but there's this red pin right here in the, oh, I think I have a laser tool. Hold on one second. This red pin right here that shows the property of the Sackets. This is in Idaho, and this is their property. You can kind of see this gray color. That's some sand and gravel that they placed on the property to try and prepare it for building. I think it was a home, building some type of building. And some important features here in this map are a fen, which is over here in this area, a tributary or a unnamed tributary, right, that goes along here. It's kind of hard to see. And then over here, kind of off screen, there's a larger tributary. And then this is Priest Lake. So those are the important water features of this scenario. And then there's also these other features like this road, and these houses. So, okay, so the EPA said, this was a wetland. You guys filled in a wetland to create this property. And it's adjacent to this jurisdictional tributary, which is that tributary that I mentioned, the Kalispell Creek. You can see it there. Despite the presence of the roads and the row of homes that separate this wetland and this fen area from the Priest Lake. So that determination was based on the finding that this is the significant nexus test, together with the similarly situated Kalispell Bay fen. The wetlands had a significant nexus to Priest Lake, and that's based on their biological, chemical, those other aspects that the interaction with Priest Lake. So they've gone to the Supreme Court twice, and this most recent argument was really about the substance of this test. And whether, this, as I said, they were discussing the ability for the average person to be able to tell this is a water, where some people would have looked at this and said, oh, this is land. It's right next to a road. There's another road on the other side. There's houses nearby. Despite its ecological significance for the area. So Section 303 of the Clean Water Act deals with water quality standards, which, as we mentioned earlier, were the province of the states prior to the Clean Water Act and continue to be the province of the states and tribes. So they are responsible for identifying and designated uses of the water bodies within their territory. There's a presumption in the statute that the fishable, swimmable uses in Section 101 can be attained. If there's, reason to believe, or if the state wants to show that they cannot be attained, then they can rebut that presumption through a use attainability analysis. So there's two types of uses. There's designated uses, and these are more like goals, use goals that may or may not be attained yet for a particular water body. And then there are existing uses, and those are uses that are actually attained in a particular water body. And on the right here, you can see some examples of uses, which range from, the Section 101A uses to some more unique and particular uses to that water body, such as ceremonial uses, industrial uses, if there's a cooling water intake or hydropower generation being used for that or cited on that particular water body. Navigation, public water supply. They're just some of the examples of uses that a state can identify for their waters. And then the other the other part of water quality standards are criteria. And these criteria are set to protect those uses that are existing and designated. And it helps determine permit limitations when permits are issued for dischargers into these waters. And so they do need to be based on scientific data, expert judgment, but they can be either numeric, expressed in numbers, the amount that can be the amount of whatever the pollutant or contaminant can be in that water, or they can be narrative, which is usually based on sensory perception, like oil sheens, floating items, odors, things like that. So an example of water quality standards in action, or kind of a unique circumstance for water quality standards, are right here in our Delaware River estuary. So the Delaware River Basin Commission has been around since I believe 1963, and they've been setting water quality standards for the estuaries, obviously, since before the Clean Water Act was enacted. And then after the Clean Water Act was enacted, the basin states, Pennsylvania, New Jersey, Delaware, they've relied on the DRBC standards when they, send every 3 years, they need to send their water quality standards to EPA for their review and approval. So they've been saying, listen, EPA, for this Delaware River estuary, we are deferring to the DRBC's water quality standards. That's the vehicle that we use to set these standards, because the Delaware River Basin Commission is a commission made up of the basin states, New York, New Jersey, Pennsylvania, Delaware, and the federal government. And, it was created to help manage the Delaware River. So the water quality standards for the Delaware River estuary were adopted in 1967. They allowed for the maintenance of residents' fish and other aquatic life, and the passage of anadromous fish, such as sturgeon on the right. That's a little baby sturgeon. I believe it's an Atlantic sturgeon. It could be a short-nosed sturgeon, but I'm not an expert on telling the two apart. And so the amount of the dissolved oxygen level in the estuary that allows for those uses was set at 3.5 milligrams per liter daily average. And in 2013, it had been several years, water quality had improved in the Delaware estuary, and the Delaware Riverkeeper Network petitioned DRBC to update its water quality standards to protect fish propagation, which means, baby fish being born. And so they wanted to add that use to the Delaware River estuary, which is certain specified zones of the Delaware River, and establish dissolved oxygen criteria that would support fish propagation, which would be more stringent than the current criteria. And so after 8 years with no new standards promulgated, Delaware Riverkeeper Network petitioned the EPA along with our partners to make a determination that updated water quality standards were necessary to satisfy the requirements of the Clean Water Act. And that was based on a provision in Section 303 of the Clean Water Act governing water quality standards. And it allows the EPA to make this type of determination, which kind of sets the ball rolling to actually get these water quality standards updated. So EPA did make that determination in December 2022. And they've set a 1-year time frame within which they're going to propose federal regulations revising the aquatic life designated uses that provide for propagation and corresponding protective criteria for the specified zones of the Delaware River estuary. And this is unique because, you know, in my research, I haven't found a situation where a petition like ours was filed and the EPA responded to that petition as opposed to review and promulgation of new water quality standards through that triennial review, which is that every 3 years when states submit water quality standards to EPA. So this is a unique situation, and it'll be interesting to see how it develops and what happens in the next few months, December 2023. Another element of water quality standards in Section 303 is anti-degradation. And so the Clean Water Act requires states to establish an anti-degradation policy that will allow them to evaluate a proposed discharge or activity that would degrade water quality. So if a state finds that, you know, this thing that we're proposing to allow is going to end up degrading water quality, they need to go through this analysis. So if degradation is allowed, it must not eliminate an existing use, right? So the bottom tier is protection of existing uses. The next is high quality waters, and the highest level of protection is outstanding natural resource waters. And in Pennsylvania, those are called exceptional value, and absolutely no degradation is allowed of exceptional value waters. In Pennsylvania, high quality waters may be degraded if there's an important social or economic justification for doing so. But again, the existing uses have to be maintained. And Section 303D is kind of addresses those waters that are impaired, which means that effluent limitations and permits that are issued by the states or EPA are not stringent enough to implement any water quality standard applicable to such waters. So, you know, no matter what type of permits are issued, these waters still have X, Y, or Z contaminant in excess of the water quality standards. So theoretically, states and tribes need to establish a total maximum daily load for waters that are impaired and submit that total maximum daily load, also known as a TMDL, to EPA for their approval or rejection, or EPA can establish a TMDL. And so the TMDL is kind of an equation. It's the sum of waste load allocations, which is the allocations of a pollutant from point sources, and then the sum of load allocations, which includes non-point sources like runoff, and you know those are not directly regulated through the Clean Water Act's permitting program, and also you know just the background level of whatever that substance happens to be in the water, plus a margin of safety. And so that equation is meant to inform the regulators on how they can reduce these waste load and load allocations in order to bring the water body into compliance with the water quality standard. It's usually created on a pollutant by pollutant basis for each particular water body. And it's very time and cost intensive and is not common and is often reserved for high profile or high priority impaired water bodies. So for example, in the Delaware River, there's a TMDL for polychlorinated biphenyls, PCBs. You might have heard of them before. They're often, you know, I always think of them as the stuff that comes out of like electrical equipment and transformers and things like that. There's a high level of them in the estuary, and the Delaware River Basin Commission, along with EPA Regions 2 and 3, came up with a TMDL for that pollutant. So here are the permitting programs. Section 402, the National Pollutant Discharge Elimination System, That title, if you remember, one of the goals of the Clean Water Act was to eliminate the discharge of all pollutants by 1985. So that's where that name comes from. And so these 402 is for that traditional point source discharge, often from industrial operations. And here permits are an exception to the Section 301 prohibition on the discharge of pollutants. So, even though the Clean Water Act has that very strong language prohibiting discharges, if you get a permit, it's allowed. And those permits do include limitations to try and minimize the pollution as much as possible. They last, NPDES permits last for 5 years for each discharger, but they can be administratively extended. Sometimes these are known as zombie permits if it lasts, decades. If the permitting authority doesn't review and approve renewal applications on time. So even if the discharger submitted an application right before their permit was about to expire, some state agencies are backlogged and they just haven't gotten to them. And those are often known as zombie permits because they may be based on outdated technology or water quality standards. And Section 404 is another big program under the Clean Water Act. This is primarily administered by the Army Corps of Engineers. And Section 404 is distinguished from Section 402 by the type of pollutant, the category of pollutant. Here it's dredged or fill material. Dredged material includes redeposit other than incidental fallback from a dredge. This is an image here of a dredging equipment, and this is, I think, considered incidental fallback that is coming out of it. And fill material is, like in the Sackets case, material that is necessary for the construction of any structure in a water of the United States, typically a wetland. People want to fill wetlands with dirt, rocks, gravel, sand, so that they can build something in that area. There's an analysis that the Army Corps has to go through, and that is to determine if there's a practicable alternative that could be less damaging to the aquatic environment. And if they end up finding that the nation's waters would be significantly degraded, then they cannot issue the permit. There are also general permits here. This is true for Section 402 as well, but general permits are for discharges that will have minimal adverse effects on the environment. And you can kind of just file a notice that your activity is covered by a general permit, and it's a little less administratively burdensome than a specific individual permit. And the 404 program, unlike the NPDES program, NPDES program, fewer states and tribes administer this program. This is typically all done by the Army Corps. And so the last section I'm going to discuss here is Section 401, and this is known as certification. This is also a very controversial provision of the Clean Water Act because it provides a process by which states and tribes can review any proposed federal activity. So this could be something that the federal government is going to do, an activity or a facility that they're going to build, or even something that somebody else is going to do that involves getting a federal permit. One area that I'm familiar with is the pipelines that FERC authorizes, the Federal Energy Regulatory Commission. So, if the permit belongs to the pipeline company, but they need that federal authorization, and that federal authorization then requires a certification from the states. And the thing that triggers certification is if the activity may result in a discharge into the navigable waters. So the state or tribe can review the activity as a whole for compliance with the Clean Water Act, the water quality standards, and any state or tribal law pertaining to water quality. This provision, like I said, it's controversial, similar to waters of the United States, because some who are concerned with environmental protection see it as a valuable tool to ensure that these projects, which are often like large scale projects that significantly affect the environment, it ensures that there will be consideration of these projects' impact on water quality. But there are others who are often subject to these requirements, often, private entities that are looking for federal permits are concerned that this is a regulatory overreach and that, a state could end up vetoing a big project just based on water quality concerns, or maybe even concerns that are only tangentially related to water quality. So those are the two kind of views of the Section 401 program. But it is a very active program and is frequently used. So that is my overview of the Clean Water Act, the basics of the Clean Water Act in honor of its 50th anniversary. And I will take any questions you may have.
Got a couple of questions coming in. One of our viewers is wondering why the definition of waters of the United States is as controversial as it is.
So it's controversial, I think, mostly because of like it's really exemplified by the Sackets case. People spend a lot of money on what they believe is land, right? And they might want to develop something there and recoup their expenses for purchasing that land. And if they find out that that land was actually a wetland and is under federal jurisdiction, then they're going to have to go through a lengthy and expensive process to try and get a Section 404 permit to develop on that land. So I think it's mostly for financial and economic reasons. Obviously, beyond that, it can be upsetting if you had plans to build something, especially like a personal home, and you find out that you can't, or that it's going to cost a lot more than you anticipated, and for that reason that you can't. But it's one of those very basic, I think, American controversies about land ownership and what you can do with your land.
So have the goals of the Clean Water Act been met? And like, what do you expect to see in the future? And are there any court cases we should be watching with regards to the future of the Clean Water Act?
Yeah, so unfortunately, those goals have not been met. There have been a lot of really dramatic improvements in water quality since the Clean Water Act was enacted, which is great. And I think, the Clean Water Act remains a very important tool. I think one thing that, it's definitely hard to address through federal legislation is land use and those non-point sources of pollution. So this is, beyond, I'm not talking about wetlands land use anymore. I mean, just straight up land use, parking lots, just roads, roads contain plenty of contamination from cars and other things that travel along them. And they all contribute to the water quality of these jurisdictional waters, but the federal government doesn't necessarily have the authority to reach that far into what's traditionally considered a state authority, which is land use. And in terms of court cases to watch, I think, that Sackets case is going to be very important, especially since the Waters of the United States rule from the Biden administration was just promulgated. So it's kind of interesting that it was promulgated while the Sackett case was under consideration, and the Supreme Court may modify, the latest, which was the Rapanos case, which had the significant nexus and the relatively permanent standard. So they might modify their view of what the waters of the United States truly means, which of course is based on the Commerce Clause authority of the United States.
Thank you. I think we probably have time for one or two more questions. If there's anyone with us who's got any lingering questions they'd like to know, or have any sort of 50th anniversary questions they want answered. All right, I think we've got everything covered and everyone's kind of digesting. Oh, we got one more in. Marie Currid asked, what rules apply to county states that want to develop paved trails along waterways?
So paved trail along the waterway, I guess, I would say, of course, the one thing to look out for is if those paved trails actually end up going through a wetland, right? The area next to a waterway could end up being a wetland. So it's always, I think, available to folks who are interested in developing land that may or may not be a wetland to contact the Army Corps. The Army Corps provides jurisdictional determinations, which means someone from the Army Corps actually comes out, looks at the area to be developed and says this is or is not a water quality or a water of the United States. But in terms of, the Clean Water Act, I think that would be the primary concern for that type of activity.
I think we have one final question. How is temperature a factor in water pollution?
Right. So temperature, it can be a discharge. It can, it depends on, for example, like in that cooling tower scenario, if there's a industry that has that intakes water for cooling purposes and then discharges that water is going to be hotter when they discharged it because they used it to cool something down, right? So I guess the thermal energy transferred to the water. So there are 402 permits that include temperature limitations, and temperature can be a water quality standard to support a certain use because temperature especially affects biological beings, a fish, baby fish, little macroinvertebrates, things like that. So, even though it's not traditionally seen as a substance or a pollutant, there is a role in controlling temperature through permits.
Great, thank you. I think it's about time to wrap up our session. I do want to thank Kacy again for taking the time to share her expertise with us during this week of Watershed Congress presentations, and have a lovely afternoon, everyone.